Okay, guys, a short one here. Just Rule 611 talks about the scope of cross and direct examination and how and when you can use leading questions. Two really brief topics. I wasn't going to separate them. If you do ever need to use them, they are found here in Rule 611. First, the scope of cross-examination. Cross-examination, other than the initial cross-examination, should not go beyond the subject matter of the direct examination immediately preceding it and matters affecting the witness's credibility. So in any cross-examination, even if it's a re-cross, you can talk about the witness's credibility. You are otherwise limited to talking about the content of the examination that immediately preceded it. But the first cross-examination is exempt from this requirement. So the plaintiffs, let's say, is a plaintiff witness. They have a direct examination. They can go through their entire direct examination, talk about whatever they want. And then the initial cross also has that same liberty to talk about whatever they want. The scope only narrows on redirect and recross and redirect and recross. And all of those examinations, direct and cross, are limited to the subject talked about in the prior examination or credibility, and that's it. But the first direct and the first cross, you have free reign to talk about everything. It's important to know. If someone tries to say that the scope isn't limited in that way, then point them to this rule, 611B. Then leading questions. Leading questions should not be used on direct except as necessary to develop the witness's testimony. Ordinarily, the court should allow leading questions, 1 on cross, and 2 when a party calls a hostile witness adverse party or witness identified with an adverse party. Let's break this down. First, 601C leading. Obviously on direct you want to open-ended questions. On cross you want to close-ended questions unless leading questions on direct are necessary. And very applicably to this case, and I'm not sure how it's going to go over if some teams try to do this, but traditionally child witnesses in federal court, you can have an instruction given that would allow attorneys to lead children on direct examination to help them get through the testimony. Namely, 15 might be a little bit old, so I don't know how much that would apply, but there are provisions, there is history in place that allows for leading questions of children on direct. That's an example of using that statement as necessary to develop the witness's testimony. So if those of you who are watching some of our scrimmage rounds in real life, expert witnesses oftentimes have their credentials given to them leading. So like they need to be on the record, but it allows the attorney to kind of speed the pace up and to make the witness only confirm that those are in fact his credentials. So the attorney is bolstering the witness as opposed to the witness bolstering himself or herself. Those are some instances where it may be permissible to use leading questions on direct examination. Usually not allowed, though. I think that it's the hard and fastness of the rule tends to be overblown a little bit, but certainly that's something you're going to see in mock trial. So I would highly recommend having a specific reason if you're going to try and lead on direct. Now, when it comes to leading on cross, specifically 601C2, 611C2, when it calls into question hostile witnesses. A hostile witness is one that should not be testifying for your side logically, but is being called because at the end of the day, they still have some useful information for your side. Last year, we as the defense called the alleged victim of the robbery, Haley Floyd, as the defense, and called him, this is Giancarlo playing him, as a hostile witness. Namely, the victim wouldn't be helping the defense that's trying to escape liability for the person who robbed the guy we're talking about. So we would call the victim and the person who allegedly committed the robbery to try and elicit this like alternate theory of how events happened. And when we did so, we gave a request to the judge to direct using leading questions, which is permissible under this rule of evidence. Hostile witnesses can be very effective. They can also be incredibly risky. But if you do want to use hostile witnesses and you do want to direct them using leading questions, then you can do so via permissions allowed under 611C2. That's all I want to talk about here. Next, we're going to be talking about impeachment and about refreshing recollection, 612 and 613, before moving on to experts. Thanks.